Good morning, good afternoon, good evening to the audiences located in the various jurisdictions. At the outset, thanks a lot to Phillipcapital for giving us an opportunity to share our thoughts, some of our ideas, some of our brainstorming sessions we had internally with you on the India-Mauritius protocol. Before we set the stage and deep dive into the India-Mauritius tax treaty and the protocol, let me set the stage before we deep dive into this. Why Mauritius is so important? If we see the financials, if we see the outflows or inflows, the FPI inflow during 2016, approximately 20% of the inflows were from Mauritius. Going further, the FDI inflows till 2015, approximately 34% was from Mauritius. And that's why Mauritius becomes a very key jurisdiction. When anybody thinks about setting up any funds in the offshore jurisdiction, the first location which comes to his mind is Mauritius. India has a double tax avoidance treaty with Mauritius. What is double tax avoidance treaty? The objective of the double taxation avoidance treaty is to minimize the cascading tax impact. India has entered into the double taxation avoidance treaty with Mauritius in 1983. It's been a long time. There have been a lot of Supreme Court decisions on the taxability on the India-Mauritius front. In some of the cases, the treaty benefits were denied, and that's why amendment or coming up with some protocol to put the litigations on hold becomes a prime objective. Till 2003, there was a Supreme Court decision of Azadi Bachao, which says that the tax residency certificate would be one of the key requirements to claim the treaty benefits. But as of today, when GAR comes into being in 2017, whether the tax residency certificate should be the sole document on which the treaty should be, benefits should be given to the SSE was an issue. And that is the reason the protocol and the amendment of the India-Mauritius treaty is very important. The government has been trying to amend this treaty since almost 5 to 10 years, and lately the discussion started in 2012. However, because of the Indian political environment, it got delayed. And finally, there is a protocol in place which gives certainty to the transactions entered into in the India-Mauritius corridor. At the outset, the protocol is just a Mauritius version of this protocol. The protocol has been referred or released by the Mauritius government. The government of India is yet to release the protocol, and for that reason, the working group committee has already been formed. One needs to wait and watch the final outcome of the working group committee, because there are certain issues which are still not addressed in the protocol, which as and when we take you forward, we'll analyze and pick up those issues. With this brief overlook and the outlook, I hand it over to my colleague Shailendra to deep dive and to make you understand the intricacies and the issues relating to this protocol.
Thank you, Manoj and Rinal, for the brief introduction and setting the tone for today's webinar and topic. Good afternoon, good morning, good evening to all the participants of the webinar today. I'd like to thank Phillipcapital again for providing us this platform to share our views on the most hot topic and the debated topic of the year, dynamics of the India-Mauritius DTAA a step closer towards tax certainty. Based on our experiences, I hope we provide justice to the subject and have made concerted efforts to simplify aspects that are involved in the India-Mauritius DTAA protocol. Moving ahead, a brief outlook of the agenda for today has been outlined for today's session, and we would talk about the background of the trade and treaty relations with Mauritius. We will also talk about the overview of the changes that they have taken place in the India-Mauritius tax treaty, the OECD perspective on this particular change, an impact assessment for investors and businesses, a review of the investment strategy for the investors that have already undertaken in India, the news briefly that you need to look out for on a go-forward basis post this amendment, key takeaways and questions thereafter. So let's understand how has the India-Mauritius partnership evolved over a period of years. On slide number 4, I'll give you a brief background and which has been ideated into this chart. The partnership has evolved besides the mythological connection with Mauritius since last 4 decades now, especially on the trade and investment front, which started sometime in early 80s when Mauritius evolved as an offshore banking jurisdiction. Post 1980 and 83s, in order to promote trade and investment between India and Mauritius, a DTAA was signed, granting various benefits including capital gains tax exemption to the investments made in India. Since globalization in 1990s, the trade and investment has grown significantly, followed by also few tax litigations that have evolved in early 2000, where the government required the need to clarify by way of certain circulars like circular number 682, 789, in order to clarify the double tax treaty provisions, especially on the count of capital gains tax exemption, which are availed by the taxpayer. The matter got aggravated as referred by Manoj in his introduction through Azadi Bachao Andolan case, Supreme Court in 2003, where the capital gains tax exemption between India-Mauritius tax treaty was extensively debated and was granted to the taxpayer. Following this litigation, in 2005, Singapore consequentially amended the tax treaty, especially the capital gains tax clause, through a protocol, building up a limitation of benefits article into its tax treaty. Here, the important point that may be noted was the capital gains tax treaty under the India-Singapore tax treaty was linked to the capital gains tax exemption with the India-Mauritius tax treaty. Especially to elaborate, any capital gains tax exemption was to be amended either favorably or adversely under the India-Mauritius tax treaty. The India-Singapore tax treaty exemption in context of the capital gains would equally be amended to that extent. The government sometime after 2005, considering the numerous litigations and tax benefits which were claimed by the taxpayer, prima facie on the basis of without a business or a substance test, the government recognized that there was a need for renegotiation of such kind of tax exemption which has been granted by the applicable tax treaties. Efforts were on since 2012 to amend these tax treaty, followed by, after 5 years of rigorous deliberation and taking cue from the OECD base erosion profit sharing project, the protocol was announced on 10th May 2016 via a press release in India, which granted the taxing rights to India, thereby providing a huge stake for investments post 2017 as depicted into the flowchart. When we look at the flowchart or the diagram, nearly more than 33% of investments are flowing from Mauritius. Going by, the next topic in the agenda would be what has changed. On slide number 6, with this brief background as narrated earlier, the typical inbound investment structures that are available in India is in two forms. On the left hand side, we can see strategic investments, whereby this is primarily used by the business community for making investments in the Indian target companies. And this is especially considered through intermediary holding jurisdictions like Mauritius. Let me elaborate what is the need for investments being made through such intermediaries. Would be especially on the count of close proximity to its market, the availability of easy and efficient financing, extensive existing presence in the intermediary holding jurisdiction, and followed by a business rationale. Besides the business rationale, intermediaries are often used for ease of setup and doing businesses, including operations and management, and also investments through these intermediaries enables efficient exit mechanism for the businesses. When you look at the diagram or the structure on the right hand side, this is typically a fund investment model which is used for making portfolio investments into India, whereby the investors through a pooling vehicle makes investment in India. The pooling vehicle could be either a tax transparent entity or a use of a master feeder fund for making portfolio investments in India, extensively regulated by the Securities Exchange Board of India here in. What we have seen based on our experiences, primarily the investments do come from US, UK and Cayman Islands, and including various other jurisdictions. So here the important question that would arise, that in situations where the subsidiary or the SPV in the case of strategic investment or the pooling fund who have invested into the Indian portfolio companies, how would they get impacted when capital gains arises on transfer or alienation of shares into the Indian entity. Going to the next slide, on slide number 7, due to protracted litigation on the capital gains tax exemption, the treaty was under the government's radar for making an amendment, especially due to the debate world over on the subject matter of tax evasion or tax avoidance or double non-taxation, especially double non-taxation when the gains arising, for instance, in situations of capital gains are not taxable either in the source country or in the resident country. For instance, one can consider or equate such kind of debates which would be subject to tax evasion or avoidance can be akin to a Google or an Amazon tax. The other area that was extensively debated was when the taxpayers were availing of the beneficial tax treaty provision in absence of a substance or a limitation of benefit test, which are prevailing or not available in the double tax free avoidance agreements. Here I may want to refer to the enhanced substance test requirement, which has been recently prescribed by MRA, the Mauritius Revenue Authority, for issuing tax residency certificate or certificate of residency to claim the tax-free benefit. Almost akin to Mauritius, even Singapore has introduced similar substance-oriented tests to issue a tax residency certificate to claim tax-free benefits. Coming to another point, there was a need to deal with the unaccounted money and the proposed OECD BEPS or base erosion profit sharing recommendations, whereby there has been enough information available and news articles and items in the media revelation. Also, reporting guidelines have been prescribed in various jurisdictions to deal with money laundering, especially on the India front, to prevent any round tripping. The India Mauritius DTAA was also under a long scanner to enhance the control and monitoring through tax information and exchange agreements entered between various jurisdictions through a double tax avoidance agreement. It has been on the priority list of OECD BEPS project as well in terms of countries exchanging information about the taxpayer. As a consequence of not sharing information, we have seen in India countries like Cyprus being prescribed under a notified jurisdiction to levy substantial taxes in India in light of absence to share information. Staying with the change that has taken place under the India Mauritius DTAA, in slide number 8, we've tried to compare the provisions between then and now which will be undertaken. The source-based capital gains taxation rights have been granted from 1st April 2017 to India, and that's setting the theme for the protocol between India Mauritius DTAA. In situations of the structure as ideated on the left hand side, when shares of the Indian company are sold by a subsidiary of a foreign parent, presently prior to 31st March 2017, capital gains tax treaty will be available under the India Mauritius DTAA, thereby granting an exemption of the capital gains tax treaty in India under Article 13(4) of the DTAA. Up to 31st March 2017, there has been no specific LOB clause or protocol to amend the capital gains tax exemption that has been prescribed. Post the proposed protocol issued on 10th May 2016, the scenario post 1st April 2017 has been changed, thereby granting source-based capital gains tax in India. The capital gains tax amendment is primarily twofold. One is when shares were acquired on or before 31st of March 2017, the same has been grandfathered. In other words, the same would not be subject to any capital gains tax in India on alienation of shares after 31st March 2017. The other limb tries to grant India full right to tax such kind of capital gains arising from shares that are acquired after 1st April 2017. Although there has been a transition provision that has been provided under Article 4 3B, stating that any acquisition of shares between 1st April 2017 and ending 31st March 2019 will be subject to a concessional tax rate in India. And this is primarily only available provided the limitation of benefit clause has been satisfied. With this, I would take you through the nitty-gritties in brief in slides 9 as to how the protocol and taxing rights to India will become operational. Here again, the capital gains tax, capital gains would be taxable in India from 1st April 2017 in the following manner. And the way we have ideated the points are, they are more investment based tax treatments. The legacy investment in shares, that is investments made on or before 31st March 2017, would be completely exempt and under the protocol. There is no impact whatsoever of the protocol and applicability of the limitation of LOB or the limitation of benefit conditions. In point 2, when the investments are being made during the intermittent period as prescribed between 1st April 2017 to 31st March 2019, concessional tax rates are available provided the LOB clause has been satisfied. The investments made during the transition period and sold will be subject to concessional rates of tax as prevailing in India, were primarily having guidance from the Direct Taxes Code 2010, which were proposed by the earlier government. This investment, this capital gains tax concession during the transition period, we believe would primarily permit the taxpayers to align their investment affairs. In the last leg or the final category, when the investments are made on or after 1st of April 2019 and sold thereafter, will be subject to full rate of tax as applicable under the Indian domestic tax laws. However, there has been an exclusion provided for any other property, like any other instrument other than shares or any other movable assets, whereby the taxing rights would still be granted to Mauritius. Having understood the brief changes into the LOB, into the protocol to the India-Mauritius DTAA amending the capital gains tax exemption, What would you mean by an LOB clause? An LOB clause is a restrictive provision to claim tax treaty benefit. Capital gains is taxable in India from 1st April 2017 to 31st March 2019, that is the transition period, at a concessional tax rate as applicable in India, only if the LOB clause has been satisfied. An LOB clause can be primarily divided into two baskets. One condition would be intent based, the intent with which the tax treaty benefit is being availed. The other condition would be fact based, whereby certain facts should be satisfied before one were to access the tax treaty benefit. Staying with the subjective test or the intent based test, it is important to identify the object with which the tax treaty benefit is being availed by the taxpayer. That means, is the object of the taxpayer just to claim the tax treaty benefit? Has to be answered to satisfy the subjective test. Another point of view would be the entity which intends to claim tax treaty benefit has to evaluate the scale of its business operations into the resident jurisdiction, followed by the facts-based test. Is for the first time the India-Mauritius tax treaty protocol under its LOB clause prescribes and refers to a shell or a conduit entity. Typically, this term has been widely elaborated into the OECD model commentary. This is for the first time that the taxpayers will be experiencing a reference to a shell or conduit entity into a live tax treaty. An entity would not be considered as a shell or conduit if the same is listed on a recognized stock exchange in its jurisdiction, or the entity meets the expenditure test in its residence jurisdiction of approximately USD 0.04 million. Interestingly, operating expenditure has not been defined either under the domestic tax law or under the tax treaties. As a result, it would be open to a liberal interpretation based on the widely accepted principles or experiences, including one thereof in relation to the India-Singapore tax treaty, which identifies and provides for an expenditure test to access the tax treaty benefits. Slide 11 would talk about the other noteworthy amendments that would impact the businesses which have been provided or proposed for changes under the India-Mauritius Double Tax Treaty. The one would be in relation to interest income, where traditionally interest income derived by Mauritius resident was taxable in India under the Indian domestic tax laws in absence of a concessional provision under Article 11 of the India-Mauritius Tax Treaty. The protocol proposes to levy a withholding tax rate on interest income at 7.5%, making Mauritius a competitive and an attractive jurisdiction for making debt investments into India. However, a corresponding change in the form of interest received by banks have become less attractive since the tax exemption of interest income derived for debt claim after 31st March 2017 will not be available. Few other amendments other than financial impact, other than issues impacting the financial institutions would be the introduction of furnishing of service PE clause or permanent establishment clause as per the UN model commentary, as per the UN model, for which the connected projects, if are carried out for over 90 days in 12 months, would trigger a service PE clause under the proposed India-Mauritius Tax Treaty. Fees for technical services are proposed to be subject to withholding tax of 10%. As regards the fees for technical services, the similar clause was absent under the erstwhile India-Mauritius Tax Treaty, granting any specified withholding tax rates. Another important change is in relation to granting of source-based tax, of source-based country, given the unrestricted right to tax in India, especially under the other income article, which is nothing but income deemed to accrue in India in situations where certain conditions are not satisfied. Other administrative provisions like exchange of information and the collection of taxes have also been provided and proposed. A step in the BEPS direction. On slide 13, I refer here and possibly refrain myself from saying that a step in the right direction, since BEPS would restrict tax treaty claim of the taxpayer. It also reminds me of the project which was initiated by OECD on the behest of G20 countries beginning 2012. The protocol of India-Mauritius tax treaty, which is sought to be amended, is primarily inspired from BEPS Action Plan 6, which talks about preventing granting of tax treaty benefit under inappropriate circumstances, as finalized in the final paper and draft submitted to submitted to G20 countries in late 2015. Identifying countries like Mauritius, that is usually used by multinational enterprises to shift its profits to a lower tax jurisdiction, Action Plan 6 of BEPS was introduced and proposed a three-pronged approach that recommended situations arising tax treaty shopping under the action plan. The first prong test was the inclusion of a principal purpose or a main purpose test, almost akin to general anti-avoidance rules. The second was recommending clarification to deny tax treaty benefit in cases of tax evasion or avoidances. And finally, the inclusion of an limitation of benefit rule in the tax treaty, which is a work in progress by the project. The final version of the LOB clause and the recommendations are likely to be released sometime this year in 2016, as confirmed into the BEPS Action Plan report, and is sought to be benchmarked on the basis of the 2016 US Model Commentary and Treaty as proposed recently. Let's look at what are the concerns or the impact that the businesses would have post these changes. In slide 15, although the amendments were inevitable, it was partially factored or ignored by the investors, raising alarm bells, and few of the challenges which we have experienced are obtaining clarity on taxability of hybrid instruments like CCD, partly paid up shares, and rights issue. For example, in cases of convertible instruments, any instrument converting after the cutoff date of 1st April 2017 will have to be examined in greater detail before any tax exemption has been granted. Realignment of the post-tax internal rate of return, the IRR, or the hurdle rate that has been granted to the investor during the transition period and post-transition period. Another point or a challenge what we have experienced based on our interactions is the allocation of tax cost or the losses to be transferred or passed on to the portfolio investors arising due to timing differences. A comprehensive compliance has also been prescribed by Securities Exchange Board in India for participatory notes to ensure greater transparency, claiming benefits under these provisions, if any. And finally, the credit for tax liability which will be suffered in India may not be available or may not be readily available in the resident jurisdiction. With these challenges and concerns, the amendment has compelled the businesses or the taxpayer to go back to the drawing board to re-strategize, rethink and refresh its investment outlook in India. On slide number 17, we have ideated few areas that may require attention and brainstorming. One would be in terms of, can the investments through Mauritius be re-strategized to leverage on the lowest withholding tax on interest amongst the tax treaties that have been entered by India, provided the beneficial ownership condition has been satisfied. Other alternate jurisdictions will have to be identified, especially which are more matured which has more matured fund regime, and also that satisfy the test of substance oriented and qualifies as a pragmatic jurisdiction. It will also have to be examined to ensure an active trade or business test has been satisfied in likelihood of proposed GAR and BEPS amendments. Further, a management of place of control and management from place of effective management regulation changes undertaken in India will also have to be undertaken. From the practical side, for the fund industry, a mechanism or a tool needs to be devised to ensure that appropriate allocation of tax cost and losses are passed on to the investors, which would require a robust tax accounting method and IT advisory system to do so. And finally, from certain foreseeable events point of view, one would have to factor in the likelihood of tax on long-term capital gains tax, which was a buzzword in the Finance Act 2016, which has not come true yet, will have to be considered, followed by tax on participatory notes and other securities. It would also be important to review the present tax clauses of the PPMs or the private placement memorandums. One of the major topic that is being extensively debated and would need a tracking would be from BEPS Action Plan 5, which provides for countering harmful tax practices, taking into account tax transparency and substance requirement, which would peg a question: what is the significance of a substance test in order to satisfy a tax treaty claim? Looking at the structure, in situations of a fund industry, the limited partnership, general partnership, or the investors coming from an offshore jurisdiction and pooling its funds under a collective investment vehicle, a master feeder fund, or using a special purpose vehicle for making investment into a source country like India, it becomes imperative to qualify the substance test at the intermediary jurisdiction level. Why would you need substance? This is especially to claim the tax treaty benefit and also to minimize the risk of source country's imposition of tax and deny tax treaty benefits if availed of. Two possible sources that are primarily used to attack the residence country claim by the source country is in the form of domestic tax law substance over form doctrine, which is nothing but, for example, a tax treaty override based on the arguments of tax avoidance, like availed by a shell or a conduit entity. For instance, in India, a treaty override is more used through a tax precedence, like in case of a McDowell's case, an old Supreme Court ruling in India. Also, GAR, which is being proposed from 1st April 2017, would often test the main purpose test before granting any tax treaty benefit. Under the international tax laws for tax treaty denial, an anti-avoidance rule can be read into the treaty based on the Vienna Convention of Law of Treaties to deny any tax treaty benefit. Interestingly, OECD commentary does refer supporting both the approaches to attack any residence country claim of the tax treaty. The relevance of this particular subject would be in light of the proposed India-Mauritius protocol, especially the shell or a conduit entity has been defined for the first time, which would raise a question that can substance or main purpose test encroach the grandfathering benefits that are available post 1st April 2017. For example, any investments made prior to 31st March 2017 and sold after 1st April 2017 that does not qualify for a substance test at the intermediary or Mauritius level, would any capital gains tax exemption be denied in absence of a substance test requirement. On a plain reading of the protocol, any encroachment of substance test in such situation of grandfathering is not provided for, and thus capital gains tax treaty exemption should be available even in likelihood of a substance test. Although one will have to wait and watch how the Indian version of the India-Mauritius tax treaty has been prescribed. Few of the tax events that or the news that the investors would want to watch out for over this period of year. On slide 20, few events which will decide the outcome of the taxability of the capital gains tax in India would be the comments and observations and outcome of the CBDT working group that has been recently formed which is a group of custodians, brokers, to address issues on the India-Mauritius protocol. The India version of the protocol amending the India-Mauritius DTAA. The renegotiations that are being proposed of other tax treaties which are almost identical, or granting capital gains tax exemption to the taxpayer, like in case of Cyprus, Netherlands and Singapore. The discussion draft that proposes to amend the OECD model for collective investment vehicles and pension funds that would be claiming tax treaty benefit, formal introduction of general anti-avoidance rule, which is proposed to be effective from 1st April 2017, and OECD BEPS policy developments under Action Plan 6, that is granting tax treaty benefit in inappropriate circumstances, and Action Plans 15, which talks about implementing these action plans through a multilateral tax treaty. As the story unfolds, it would bring clarity on the position which are unclear in the amendment, especially to augment streamlining of the investments that are in India. Finally, few departing thoughts before we address questions. Though the amendment was imminent due to the global events, the investor community have reacted positively in the markets. As the issue gains gravity of maturity, it's time to weigh risk and returns for the investors and evaluate especially an impact on the investments in jurisdictions proposing similar LOB clause. Here I'm referring to a case of Singapore, which has a similar tax treaty exemption as that of Mauritius. And interestingly, in light of no present renegotiation or amendment that will take place post 1st of April 2017, there will not be any tax treaty exemption that will be granted under the India-Singapore tax treaty for capital gains tax. Also consider migration strategy through cross-border restructuring to realign and ensure that such investment are considered for the taxability in future. Possibility of entity conversion or recharacterization based on certain domestic tax law benefits available in India. Make optimum use of the debt and other securities relaxation prescribed under the protocol. Also, maximizing and leveraging the grandfathering clause that has been available and permitted to the taxpayer, followed by a review of tax indemnity or clauses available or drafted in the investment agreements. With this brief technical session, I open the floor for questions.
you can type your questions on the question or the text chat box, which is at the bottom of the panel.
Yeah, there's a first question which has come. What is the impact on the instruments other than shares like derivatives, debt instruments, which are not characterized as shares?
Thank you. So the protocol amends the taxing rights in cases of capital gains primarily arising from alienation of shares, and the definition is narrowed down to shares and does not use the term securities. Hence, in case of any other instrument or other securities, the capital gains tax exemption on alienation of such instruments would definitely continue to be governed by the residence-based taxation that is in Mauritius.
Yeah, and just to add further, this is the Mauritius version of the protocol, so one needs to wait about the Indian version, whether it has been accepted verbatim or if there's any changes pursuant thereto.
That is correct.
The next question is a very interesting question. What is the tax implications on participatory notes or PN holders?
So, thank you very much. And participatory notes have been long debated in terms of taxability in an FII or a FPI regime. And interestingly, there has been, post the amendment of the India-Mauritius DTAA in this protocol, there would not be any direct implication of these participatory notes, and therefore there would not be any implication from taxability point of view on such instruments, although it may be interesting to note that Securities Exchange Board in India has prescribed recently a robust compliance or a know your client norm to ensure tax transparency of these participatory note holders. Thank you.
Due to paucity of time, I think we have overstretched the timelines. We'll take the last question. Does this amendment impact the India-Singapore DTAA?
This is an interesting one, and as I spoke in my technical session earlier, interestingly, the protocol of India-Singapore Tax Treaty entered in 2005 has got a coterminous or a linked capital gains tax exemption clause to the India-Mauritius Tax Treaty, thus effectively providing that so long as the capital gains tax exemption is available under the India-Mauritius Tax Treaty, the India-Singapore Tax Treaty would tend to honor such India-Singapore Tax Treaty capital gains tax treaty benefit. In case of any amendment taxing India capital gains under the India-Mauritius Tax Treaty, a similar amendment would be undertaken under the India-Singapore Tax Treaty, especially for capital gains tax situations. and therefore it becomes quite important to evaluate and understand the implications thereof, especially in light when the discussions is now being considered by the government to also renegotiate the India-Singapore tax treaty on the similar lines. Thank you.
Thank you, Manoj. Thank you, Shailendra, for such a detailed presentation on the India-Mauritius taxation treaty, which is gonna come into effect from 1st of April 2017. Since we have already crossed our time, so in case you have any other queries, you can definitely get in touch with us. You can forward your queries to us, and then we can connect it to Manoj or Shailendra to get those queries answered. Thank you all for patiently listening. And with this, I, on behalf of Phillipcapital, would wind up this webinar. Thank you.